We had several legal acts within European Union, within single member states, and all over the world. And secondly, the problems of responsibility and governance are emerging as the central problem within this pandemic. And one of the topics to discuss is who is in charge of what. This morning in the opening session, Professor Costato said we need again some sort of international governance. The question is where it is, this international governance. Are we trying to get it? May we get it, and in which way? And we have, in my impression, when we are speaking about responsibilities, of course, we are still speaking about governance. I spoke with an Italian colleague some weeks ago about the title of this Congress, and he said responsibility, but we are not speaking about responsabilità, but responsabilità in Italian means also liability. Here the discussion is not about liability. In German language, you have two different words. In English language, in Italian, we have only one word, responsabilità, as responsibility and as liability. What we want to think about now is responsibility as governance and as competence. So what are the possible reaction of lawyers before these new legal acts, and especially of lawyers studying agriculture and food? I think that there are 2 points that are emerging clearly in these months from this experience. First of all, we are now finally taken to speak about agri-food law or agri-food regulation and not law of food as such. And this is a conclusion which I don't want to put as a sort of ideological conclusion, but it is a conclusion that, in my opinion, is based on what is happening in the field, in the area of regulation. The second point which is emerging is that we are facing the search of a sort of systemic answer and the search of systemic regulation. We listened this morning to some very interesting speeches regarding the proposals of reform of the common agricultural policy, and also the proposals of reform of many other parts of the legal system, like controls and so on. All this moves us to a consideration of an holistic, this word has been used even this morning, holistic perspective that includes human health and food safety, of course, but includes also food security, this sort of word that was abandoned for some time and now is rediscovered, food sovereignty, but even market and competition rules. We had a session this morning just dedicated and chaired by Professor Iannarelli on market and competition rules, and we have seen how many difficulties people operating in this market are now facing. Then the other point is the point of who are the actors within this theater. Actors which are both public and private actors, and actors on different theaters. Theater of production, but even theater of communication, and the theater of the social rules. So we organized this comparative session just because the idea is that comparison is a really powerful tool, not only to understand foreign experience, but even to better look to our experience. And we must say that from a sort of first looking to these experiences, we had many tentative answers which have been given in national states, in European Union, in other organizations, but I would say tentative answers. My impression, but I will be open to any discussion on this point, is that until today, we didn't got the final answer that we would like to receive. And there is a second consideration. What happened about international institutions? I don't want to go now on the discussion on the role played or not played by the World Health Organization. But in fact, we must admit that international institutions did not play an effective role in this case. We had some cases, relevant, significant, of international cooperation, but more on the basis of a single relation among single member states. We had help from China, for example, from Cuba, from Germany, I intend in Italy, from Russia in the first months of the pandemic, but through direct negotiations, not within a general. Now we are facing some sort of tentative research of an answer with reference to the vaccine in the European Union. We will speak on it also. And also, we got some cases of legal transplants. We spoke of legal transplants even last year in our Congress of Portici, and this topic, this area of discussion is coming back now, today, even in those days. But there is something which we didn't imagine last year. I have taken in my short abstract of the presentation some words of John Belushi in Animal House when he said, when the going gets tough, the tough get going. And when it is hard to play, hard people play. And the impression is that nowadays international organizations are showing showing their weakness and leaving the place to other subjects who are exercising effective governance. This seems to be the central point. Who is in charge of what and who is exercising this? And so a comparative analysis, just to mention a few experiences at European level. I've been impressed to look to a rule of the Treaty on the Functioning of the European Union, Article 168 on public health, that says the Union action shall cover the fight against major health scourges. It is just what we are dealing today. And also saying that Union will monitor early warning and combat serious cross-border threats to health. Serious cross-borders. This is the central point. This is what we have today. We must admit that not only in the first months, when this experience was very new, but even later on, and even today, we are still facing a very difficult job for the European institution to find a common shared line regarding cross-border. We had single member states who adopted rules regarding circulation of persons, circulation of goods, opening or not opening. Just during these days, there is a large discussion on opening in Christmas, the snow season, the snow station, and so on. And in fact, I can imagine how difficult is this. This from the side of the difficulty. But we have another part of the story, if we stay to the European Union experience. And the other part of the story is that we had a shift in the attention in the official documents regarding the common agricultural policy, that in the famous document that has been discussed very deeply by some scholars and speakers this morning, the Commission, with the new document from Farm to Fork, rediscovered expressly the word food security, with an expression that you can find in this document of May 22, which is 2020, saying the COVID pandemic has underlined the importance of a robust and resilient food system that functions in all circumstances and is capable of ensuring access to a sufficient supply of affordable food for citizens. And what is interesting is that if you look to this document, you will find a chapter with the title Food Security. You didn't find the mention of food security in the document a few months before, at the end of 2019, proposing the reform of the Common Agricultural Policy that was all considering the problem of environment, of course, the problem of avoiding any sort of pollution, which is correct, but not this one. This topic is a topic that came back in the discussion in Common Agricultural Policy in 2013, when we had the last reform of the Common Agricultural Policy. In that document, the Commission was speaking about global food security. In some way, how to say, speaking of something that at that time was not so clear as it is today. But in fact, then the effective regulations adopted did not consider so much this point. Secondly, what is the other point? Even if we must say, and Paolo Borghi and Gianluca Brunori underlined this morning, that this is the new position or the rediscovered position expressed by the Commission in this document of May 2020, but we have to see what will be the final text of the regulation, because it is not clear whether or not this will be effectively considered. On the other side, we have another important point, just starting from food, and this is why I think that as agri-food lawyers, we have a sort of privilege of a peculiar point of view, looking things that happen in advance with other sector. And I'm just here referring to that very well-known document, which is the Regulation on Official Control of Food of 2017, Regulation 625, that adopted an integrated approach to the control of all the cycle of life, not only of what is in the food chain, but anything which is living. So including welfare of animals which are not connected to food. And the example that some speaker made also this morning of what is happening nowadays in some parts of Europe with reference to minks that have been slaughtered for possible dangers for human health, related or not related to COVID. This is not very clear from the scientific point of view, but gives this idea of this systemic approach. And what is relevant is that today we are discussing under the stress of a crisis, as we have done years ago when we discussed it under the crisis of BSE. But on the other side, this new regulation of 3 years ago has been adopted without the stress of the crisis. And Professor Marco Goldoni this morning pointed on the significant relation that we traditionally had in agricultural and food experience and rules regarding the relation between scientific innovation, technical innovation, and legal innovation. Most times, legal innovations comes as an answer to the challenges of scientific or technical innovation. In other cases, legal innovation come in advance, they are proactive, and that was one of the cases. And so there is the third point that I just want to mention to you as an interesting point of what is happening in European legislation. I mean, when I use the word European, I mean European Union legislation. And there are these recent new regulations of the Commission. One, which has been mentioned this morning even by other speakers, Regulation 466 on the cross-border controls. And it is interesting that you find in this regulation 2 points that work together. From one side, it is a regulation adopted on the basis of the General Regulation on Official Control of 2017, which had nothing to do with pandemic, with COVID. At that time, nobody spoke about that. But on the other side, there is an express mention of COVID and pandemia today. And so the answer is that of a systemic approach based on that model, which was a legal, innovative model introduced. And now we are just finding, or trying to find, the Commission is trying to find some legal solution to these challenges of today, challenges created by pandemia, using that innovative tools introduced 3 years ago. And secondly, there are many implementing regulation or execution regulations adopted by the Commission in the last few months. But the other one, which is interesting, just with reference to COVID pandemia, but using as basis that general regulation of fishery control of 2017, which is regarding dematerialized control and dematerialized certification. We listened to an interesting speech of Professor Spoto this morning on Internet of Things and dematerialized controls and the new tools that we have. And Professor Iannarelli said, we must admit the things will never be the same. I totally agree with that. And what we are looking today is that even that very sensitive area of controls is an area now experimenting new tools, but based on a systemic approach, which is the systemic approach of the agri-food chain thoroughly considered. So going back very fast, I don't want to take too much time and stay in my limit. What about the Italian speaker? Just to some elements to our foreign colleagues, just to compare. What happened in Italy during these months? Of course, we had, and still today, we are listening to administrative and legislative measures regarding free movement of people. Just this morning in the newspaper, we read that there is a proposal of the government that says that the Italian that will fly abroad for Christmas will be forced to 15 days of lockdown at home when they come back. This is a sort of trying to give an answer to what didn't happen at European level from one side. On the other side, decisions on opening or closing commercial structures with a lot of litigation, even before administrative courts, before the national state, the national Italian states and regions, and even in those cases, peculiar rules regarding food. This morning, Professor Sakamfra said, food and medicine share a special status. And this is true even in this occasion regarding that. But even we had a lot of specific rules adopted in Italy. Just to give a very short list, just to think about later on, regarding, for example, communication of the quality of agri-food products and communication on the claims. We had some cases already examined by the antitrust authority in Italy, who is also the authority for deceptive advertising, or examined by the Office of the Ministry of Agricultural Policy against food frauds and food false communication, on some producers claiming some qualities against COVID or for immunization of their food, qualities which were not demonstrated. And so this is also another point. And in fact, we had even some specific rules adopted regarding this sort of claims and regarding sanctions against this sort of claim. On the other side, if we go to the rules of the market, it has been remembered this morning by Professor Iannarelli that we had even some examples of a consideration from the Italian antitrust authority with a different or a slightly different perspective toward agreement among producers along the food chain with reference to this specific point, which is the point of the agreements to face the COVID. This is the other point to consider. And another point, which is interesting, and I just have to submit to our colleagues from other countries. We had, along the last series of months, many changes with the name temporary changes, and national changes, to the rules of production and sale and maintenance of many PDO and PGI products. I just want to mention you only one example, that is that of the mozzarella di bufala campana. We had cases during last years regarding whether or not it could be used iced milk, because the bufala campana, the cow from Campania, produces milk more in winter, but the request of mozzarella di bufala is higher in summer. So the question is, may the producer maintain iced the milk in winter and use it in summer? It was not allowed by the bylaws, but nowadays it has been admitted for a limited period of time. And also we had some temporary modifications on the production of some wines, or some cheese, some hams, and so on. The question is, are those temporary modifications to stay, or they will really finish? And the question is, how to deal with a globalized market when you are based on local production? This is another question that this COVID emergency is putting to the legislator and to the regulator. Then going back to the real civil law, some of the speakers today already mentioned, we had a very new rule introducing the possibility of revolving pledge, and so dematerialized pledge for products like PDO and PGI and even wines. We had this experience in past years, but only for very specified products, some cheese. Nowadays, this is a new rules admitted for all. And even in this case, the pressure of the COVID emergency, which was a pressure not only on human health, but even on the economic situation of the market, moved the legislator to go on some very sensitive point of civil rules. And I'm just running to the end of this very long list of things. We had new rules assigned to the custom authority. We were thinking that custom authority were a sort of relic of the past, like the flipper or things like that, like the telefax, in a globalized world. Nowadays, custom authorities are recovering and regetting importance, competence, authority due to this situation. And finally, staying within the area of civil relation, of contractor relation. Tomorrow morning, we will have a speech speaking especially on this point, how the idea of fair cooperation, which is an idea that has been, considered as fair cooperation between public authorities, may be used today even in relation among private people in their contractual relation, when the general situation changes so much. This morning, some speakers spoke of the sort of possible comparison between what is happening now and what happened during the war time. And it is significant that a very relevant innovation in the Italian Civil Code, admitting the relevance of excessive burden supervenience, has been introduced during the First World War and then became a general consideration. Nowadays, we are facing this with reference, for example, to rent contract and so on, regarding commercial places, but even houses and so on. The final point, what is? There is a new increased attention toward sovereignty in general terms. Sovereignty in national terms, nowadays even very respected scholars of constitutional law are rediscovering the rules within our constitution that maintain the role of the central state after some decades when we were thinking only on regions. On the other side, even in Europe, there is a recent document of the French Association of Agricultural Economists with the, how to say, approval of the state, saying the COVID-19 pandemic revealed deficiencies and distortions in the global food supply chain and agricultural production system, and so important questions regarding sovereignty and food security highlighted. My impression is that nowadays we as lawyers are urged to rethink how to look to institutions at national, European and international level, and to adapt new models to offer some possible answer to this essential problem, and how to give governance to the agri-food sector, recognizing the special nature of this sector, which is intimately connected to human health. In this perspective, I think that the contribution from the colleagues from other legal systems will be a very significant tool, and I thank them to being here, and I'm pleased to give the word to the colleague Martin Holle from the University of Hamburg. Please, Martin, it is up to you.
Hello, good afternoon or good morning, depending on where you are, everyone. And yeah, thank you very much, Ferdinando, for the kind introduction and your introductory remarks, which are, I'm sure, will lead to some additional discussion, I'm sure. And yeah, I would like to give a country report basically on Germany. Let me check if I could put up this here. Yeah, looks good on my side at least. And yeah, but let me also start with a few words before I start going into the overview. I picked out a few aspects. It's far too comprehensive to deal with it, of course, in 20 minutes, but try to give you some highlights. But when this COVID pandemic started and the virus started spreading, I think one thing that was quite remarkable to me is that well, international collaboration mainly was maintained on a scientific level, while on an official and regulatory level, it was more the hour of the national state and the executive. So it was a lot of reversals, which we wouldn't have even thought of in the European Union, border closures in the Schengen area, something we couldn't even have imagined, I think, a year or two ago. So it was a really remarkable process. And emergency laws were applied that probably were used the last time decades ago in other crises. And this is something that raises, of course, some important questions. Of course, I cannot address all of them, but I picked out two of them. So the one question is, of course, what should be the role of the EU and international organizations? And I think we have seen that the EU in the beginning of this crisis or pandemic was struggling to find its role. And because out of sudden, member states started taking initiatives unilaterally in many areas. So it's not necessarily the fault of the European Union, but they noticed that at the beginning, there was not very much they could do other than ask the member states to come together and to talk and to find an agreed way forward. But that took a while until this happened. And the second question, which is more a constitutional law question, is if you think about administrative measures and emergency measures, who within a state should be responsible from a constitutional law and fundamental rights perspective? And this is also something that has been reflected in the discussion in Germany, not in the beginning, but over time. So we had some very intense discussions in the last 2 weeks, also within our parliament, the federal parliament, on how much should the parliamentarians be involved in the decisions on which measures should be taken, and how much should it be the role of the government. So there's also some a discussion, and maybe also a try of parliamentarians to regain more control now on these measures that are taken. So what I would like to talk about is, as I said, it's focusing on Germany. And the first part is first the effects of COVID-19 on the agri-food sector in general, then also the restrictions of free movement of goods, services, and people. That, of course, has a major effect and has multiple consequences. And consumer behavior also changed during the pandemic, which is also quite interesting to observe. Food security was affected, something Ferdinando also mentioned already in the introduction. Food safety, but working conditions was a big topic in Germany as well, in particular in slaughterhouses. And also some issues in civil law about validity of contractual obligations. But also if you look at agri-food companies and also the hospitality sector, the question of insurance cover, if the business gets closed, many business have an insurance for that, but it has certain terms and conditions that come with it. And so we had quite a bit of litigation on that aspect as well. And of course, I will then try to give a bit of an outlook and draw some conclusions. So starting with the effects of COVID-19 on the agri-food sector, of course, the biggest effect is certainly caused by the restriction of free movement of goods, services, and people, because we have seen border closures and travel restrictions that would also affect the supply chain and the logistics sector in particular, but also the movement of workforce, seasonal workers, for example. The quarantine requirements have an impact on also the consumers and the sales data and figures, and the closure of businesses in phases of lockdown has of course severe consequences as well. When we look at the harvest and production side of things, then the limited availability of seasonal workers was a big problem, and particularly in the beginning, in the springtime and early summer. And factory closures that were caused by outbreaks also impacted on the possibility to run a continuous production. So it was quite disruptive for some businesses. Interruption of supply chain made it difficult to obtain raw materials. Sometimes also some other equipment was probably not available, and product availability sometimes was also reduced. In the hospitality sector, we saw, of course, restrictions. First of all, closures during lockdown, of course, but also limited business hours, reduced seating capacities, and cost for additional hygiene measures that impacted massively on the sector. And probably this area was much more affected than the original agricultural and food production sector. In retail, they were probably doing the best within the crisis still. If we look at the whole chain, they had an entirely different problem, that there were sudden peaks in demand and a limited availability of some products. But also there was a move from stationary to internet trade and home delivery, which also impacted on the sales of stationary businesses. A boost in contactless payments, at least in Germany. Germany was a country where people were always a bit suspicious about contactless payment, and we still believed very much in our cash. but that has changed dramatically over the last few months. And also the cost for hygiene measures again that need to be taken, and also limited entry of customers, etc. And then, of course, what about contractual obligations? Whose risk is it if, because of the pandemic, a certain service cannot be performed or a certain good cannot be delivered? So who should bear the risk of that? And there are many possible constellations I will not be able to discuss here in detail, but I'll give at least some considerations. Yeah, for the timeline, in Germany on 25th of March 2020, the German Federal Parliament declared an epidemic situation of national significance, which is the precondition that some emergency laws, the German Protection Against Infection Act, enter into force. Of course, this act is there also for the usual cases of infections, and there are also requirements with regard to labor law, for example, and in workplaces, also some requirements are regulated by this act. But there are also some measures in case of a pandemic, and those were activated basically by this declaration. And only 2 days later, the law on the protection of the population in an epidemic situation was published and entered into force 3 days later. And with this law, quite a lot of executive and regulatory powers were attributed to the Ministry of Health. And there was also an additional right created for the ministry to request, process, and store passenger data from planes and ships and trains if necessary, so to trace possible infections. It was also granted permission for certain qualified healthcare professionals like nurses and paramedics to administer medical treatments, something which otherwise in Germany is prohibited. It can only be done by a doctor. And this was alleviated here a bit. And there's also an exemption for the building of temporary hospitals from building permissions, for example. So all measures that were preparing to act more quickly than usual and to provide additional support in dealing with the crisis. Border controls were reintroduced also in March 2020 for Austria, Denmark, France, Luxembourg, and Switzerland, which was always on a mutual basis. And it's always seemed a bit odd to me why we had border controls in Luxembourg and France, but we had no controls to Belgium and to the Netherlands. So in a way, there were where infection rates were often quite similar. So this was not always quite logic. Of course, it was always a reaction to a rise in infection rates in bordering areas, but still the entire logic that has never occurred to me really. Then an obligation was created of travelers who had to go into quarantine to provide their identity, travel itinerary, and contact data to the competent authorities. So a kind of landing card was introduced for planes, for example. And the entry and quarantine requirements, interestingly enough, in Germany are not a matter of the federal state, but of the states, of our 16 states, the Länder. And they set their own requirements, and they were not always the same in every single state, which created quite a bit of confusion from time to time. There was in the beginning, in general, at least they agreed in a joint conference to have a 14-day quarantine requirement, and then later it was changed to 10 days, and then it was linked to a test and could be shortened, and it changed over time. But always it was a matter of the states and not of the federal government. Exemptions were created already from the beginning for persons who professionally transport goods and commodities, so truck drivers, for example, but also crews of planes, ships, trains, and buses, and workers in essential infrastructure, health services, and public administration. Some branches, essential branches of public administration that are required to maintain the public order, for example, and also for cross-border commuters. However, in some local areas that got a bit more restricted, the border to France, for example, there was a complete closure for a while. Yeah, the consequences of these restrictions was, for example, that in March 2020, not only from Germany, but some other countries, including Italy, France, Spain, Austria, that 250,000 Romanian seasonal workers had to return home after their employment ended, which meant, of course, also that this workforce was missing or lacking for the work in the agricultural sector, for which they were hired. No new workers in Germany were allowed to enter the country as of 25th March. And so there was a lot of concern of farmers that they wouldn't have enough people to harvest their products, and that was had to be addressed and was addressed a month later. Border controls initially resulted, of course, in long queues and caused delays in the delivery of goods, and also made it more difficult to maintain just-in-time production. For example, a shortage of raw materials occurred in some areas, and a shortage of some imported foods. And also labels ran short for products. So it was not the product itself, but the label that was lacking and was not available. And so some solutions had to be found for the use of old labels, even with maybe probably a new recipe if there were no substantial changes in the product. But that was a very limited exercise. And of course, there was a significant loss of business in the hospitality sector because there was no tourism anymore. Legal basis for measures in Germany is at that time was a very generic one, in this Protection Against Infection Act. And the act basically says that the competent authorities can take all the necessary protective measures to prevent the spread of communicable diseases. And on that basis, to a large degree, initially the measures were run. This is maybe typically German construct where we have a general clause, which is quite wide, but you have, on the other hand, the principle of proportionality, which limits it, which says it's only permitted and it's only necessary if it's the least invasive mean that you can use, mechanism that you can use to serve the aim and to reach the aim, and you should not do disproportionate damage to those people who suffer from it. So you always have to balance how important is the goal and how relevant are the interests of those that are affected by the measure. But of course, it's something that if it runs for a longer time may become a concern if everything is put on this or based on such a very generic clause. In Section 32 of our Protection Against Infection Act in Germany, there is also the opportunity or power to issue ordinances. The governments of the Länder, also our states, can issue ordinances where they give additional regulations and can put out additional restrictions. That has been done in all the states, and every single state had their own ordinance on COVID-19 measures. So the power is with the authorities of the states, the Länder, and not with the federal government. And so depending on the rates of infections, the rules were less strict in some in some states than in others. And so that led also sometimes to confusion in areas where states are bordering, because 500 meter or 100 meter away, you may have two different, completely different sets of rules. And the powers of the federal government in this pandemic are mainly limited to border controls, at least when it comes to COVID-related measures. And there was criticism of that, at least in the last few months, and there was increased level of criticism that the decisions on restrictions and all these measures were taken by the government without relevant participation of parliament. So after this first adjustment, all the individual restrictions were negotiated between our federal government and the government of the states in video conferences. So it was not a very public process. Of course, our parliament passed a lot of laws that were supporting basically those measures, and also about support for industry or businesses that were affected by closures and things like that, financial support that can be claimed. But the restrictions themselves were always more a matter of governments, and the different rules in different states also were not easy to explain to the population. So if I take Hamburg, which is here in the center, which is the state where I live, it's a city and a state, so a very limited area. Then Hamburg has currently the rule that at the moment, maximum 10 people from 2 households are permitted to meet in public and in private. Of course, nobody is now doing checks in the houses, so it's more something that people should adhere to, but nobody will do searches at homes whether there are more than 10 people, but this is the general rule. If we go to Schleswig-Holstein, which is the neighboring state on this side, on the north of the river, it's maximum 10 people from 2 households in public and maximum 10 people from any number of households in private. And yes, I can only say I live about here, and I can walk up to 100 meters here, and then I'm in Schleswig-Holstein. That means that I would have a different rule. So if I want to meet friends in Schleswig-Holstein, I can do that, but I can't do it in Hamburg. In Lower Saxony, which is the southern state bordering Hamburg, you have maximum 10 people from 2 households in public and in private, like in Hamburg. But if it's from the same family, it can be any number of households. So there's no restriction on the number of households if it's concerning the same family. Now you can debate who belongs to the family. That's another discussion. I'll not put that up here. So it's a bit confusing, but if you look at the infection rates, you will see that it might make some sense. So the infections per 100,000 per week, we had in Hamburg 131.7, in Lower Saxony 101.9, and in Schleswig-Holstein 47.2. So as you can see, the strictest rules are in those areas where we have the highest infection rates, and the most lenient ones in that state that has the lowest infection rates. So this federal system also allows to adjust to specific situations, but on the other hand, so it's very flexible. But on the other hand, of course, it's also sometimes a bit confusing, those messages for the population. What we see in the last few months is that we have an increasing level of coordination on federal level in joint conferences of federal and state governments. And the Protection Against Infection Act got revised on 20th November, so just last week. And now we have more specific measures, 17 dedicated measures to tackle COVID-19, starting with social distancing and mask requirements up to a full or partial lockdown that can be ordered. So we don't have only this vague general clause, but we now have also a list of specific measures that authorities can take. There are also some areas which are very particularly relevant from a fundamental rights perspective, demonstrations, religious services, but also order of a curfew and prohibition to enter hospitals or care homes completely is only permitted as a last resort if all other measures have not been effective. So that's also now specifically specified in the law. And also if there are restrictions for hospitals and care homes, then they still must allow to maintain a minimum of social contact, so to prevent isolation, particularly of elderly people. We had a lot of court cases. Germany, we have a lot of lawyers, so we have a lot of court cases, and almost everything got challenged in the food sector, not only in the food sector, but also beyond. So the obligation to wear face masks in food retail establishments, that was unsuccessful. Then there was a debate when only shops were allowed to open that provide essential goods. Then there was a debate, or one authority took the view that luxury food items like chocolates, wine, and culinary specialties are not essential because it's not something you eat as a staple. But this was successfully challenged before the court because the court held that food meant all foods, and there was no distinction between essential foods and non-essential foods. So everybody was allowed to buy wine and chocolates again. Other challenges were less successful. Prohibition to sell through mobile stalls, that was unsuccessful, that challenge, because they were not food retailing, and the courts confirmed that. Another interesting discussion was about shops which provided a mixed range of goods, so not only foods, but also maybe other household goods, for example. And there the laws in the States were again slightly different. There was one which says mainly foods, then foods and beverages. Then the courts held that should be more than 50%. While in others, it said only substantial percentage of their offering must be such foods and beverages. And then the court said maybe it's something like 25 or 30% would be enough. So again, different solutions in different states. Yeah, and even the non-commercial fishing ponds were closed, and the question was whether fishing has to do with food, and or whether this is done for pleasure. And these were non-commercial, uncommercial clubs that were doing fishing more as a leisure activity. The court said this is not part of the food supply, and so they were not permitted to open. Like any other sports and leisure facility, they had to be closed. Post-lockdown, we had other challenges. There was a restriction to sell foods and drinks after 10 o'clock in the evening. That was successfully challenged because the court got the impression that there was not a sufficient rationale how that should contribute to the limitation of spreading COVID-19, because you can always argue, of course, that the people start drinking just earlier and then nothing changes. Unsuccessful were the other two challenges: prohibition of fairs, wine and beer festivals over the summer. That was still upheld because the court held that it was a dynamic situation, and these mass events were still considered a substantial risk. And also the minimum distance of 1.5 meters in Germany between guests in the hospitality sector was accepted by the courts. So overall, you can say in the first lockdown phase, the courts mostly confirmed the restrictions and accepted the public health argument. And but there was also an aspect that helped to defend these measures in the courts, which was that they were temporary in nature. And the courts always stressed very much that the regulators and authorities have to constantly review the situation and adapt to the new situation. And the more knowledge was generated about COVID-19, the more skeptical the courts also became about the necessity of certain measures. So they were asking more questions, or more specific questions. The Federal Constitutional Court was also very quickly busy with different COVID-19 restrictions, where in Germany everybody can file a complaint to the Constitutional Court if he feels violated in his constitutional rights. Of course, we have to go through the whole legal system beforehand. But there were some quite pointed remarks by the court saying that at the first step, at the early phase, it's crucial to slow the further spreading, and that requires strict limitation of contacts, because only in that way you can prevent the collapse of the public healthcare system. And to achieve this, even severe restrictions of fundamental rights like the freedom of religion by closing churches for service can be justified, provided that they are limited in time. So again, this temporary aspect is very important. Then in later decisions, again, the court stressed that it's a dynamic and volatile event, and that the legislator and also the authorities have to bear that in mind and have to follow the development very closely. And with regard to demonstrations, that's maybe also quite interesting. There was a demonstration against the corona restrictions, and the authorities, police authorities, ordered basically that the demonstrators have to wear a face mask during that demonstration against those restrictions. And so they said, well, what's the point then to demonstrate if we have to wear a mask? But also there, the Constitutional Court said that this restriction to wear a face mask does not endanger the success of the event in a way that it would severely violate the constitutional right to give your opinion. So also that was upheld, basically, that limitation or restriction. Yeah, after this aspect of restrictions, let me now have a look also at consumer behavior. So in the early days, we have seen, I think in most countries, a stockpiling or panic buying of consumer goods. The overall favorites, I think, are the three ones I pointed out here. So pasta, flour, milk, rice as well, and some other items. But I also have some local favorites here, which may give some indication on the national character, even it may be a limited one. So this first one is feta cheese in Greece. It was a popular item to stockpile. In Finland, it was 5-liter cartons of wine. In the Netherlands, it was wheat, of course, and in Germany, it was toilet paper. So we didn't care so much about stockpiling wine, but toilet paper seemed more important to us. Yeah, how was this stockpiling or panic buying issue managed? I think in most countries by such signs. So retailers limited the sales to 2 items per customer, for example, or a limited number at least. And again, that poses some interesting questions from a legal perspective. So how should we leave it to retailers to react to this stockpiling alone? What about stockpiling through online purchases? So if you order 100 items via the internet, and at what stage should the state intervene? And is this required? And at what stage is it permitted? And again, in Germany, we have a law on ensuring the basic supply of food in a supply crisis. But this will only be initiated once it's officially proclaimed that there's a vital need the vital need for food in essential parts of our territory is endangered due to war, natural disaster, particularly serious accident, an act of sabotage, an economic crisis, or any other comparable event. And so far, it was stated all these stockpiling issues were temporary and they went away quite quickly again. So the state didn't have to intervene here. Yeah. But there's also, to this point of stockpiling, there's of course also a food security aspect to it. If you have this limited availability and the logistic chain gets overwhelmed, then this will lead to price increases, and not all consumers will be able to switch very quickly to other alternative products, particularly if they have a low income. Also, people with allergies may struggle to find the products that are free of these allergies that they usually buy. And so that has an impact on availability of foods. And in our social courts, there was a there were a few cases about the question whether people that receive state benefits should be entitled to an extra COVID grant to cover higher prices of foods and an increased level of stock keeping that was recommended by the authorities. And all higher social courts in the various states basically have rejected that action or that claim, because they said this is not something that is strictly necessary to maintain your adequate level of food. So this may sound a bit harsh, but it was the same solution in all states, basically, and same decisions in all states. So our social security system doesn't foresee basically this special payments. Looking at food safety, it was pretty clear from quite early on after EFSA, also, and in Germany we had also the German Institute for Risk Assessment giving an opinion that infections through foods and packaging are unlikely. So there was not so much concern about that. So normal hygiene procedures should be sufficient to deal with this. The other question was what happens if there are contact restrictions and limitations during lockdown? What happens to the official controls that usually are done in person? And I just checked this yesterday with our officials here in Hamburg, and they told me that there were no specific constraints or limitations, that all planned controls have taken place, and there was no specific need to invoke any special rights or limitations here. What was applied, though, is this opportunity that was created in the implementing regulation 2020-466 that Ferdinando also mentioned earlier. So at our border controls, we accepted electronic copies of originals of veterinary certificates, provided that the original will be submitted later or provided later on. We had also this problem of rogue traders that advertise preventive or curative effects against COVID-19 to foods or food supplements, a lot of them online. And there we have an EU action taken already in April 2020, an action plan on online offers and advertising of food related to COVID-19. So there's concerted action between the member states in this sector. On the working conditions, that was something, there was a lot of media coverage in Germany, in particularly concerning slaughterhouses. But the first thing that had to be created was a lift of the entry restrictions for seasonal workers, because they were needed in agriculture mainly. That was partially lifted in April 2020, provided that certain hygiene conditions and the hygiene management plan was in place. And on top of that, there was also flexibilization of working time regulation, so people could work longer, up to 12 hours a day with a rest period of only 9 hours, which meant that in particularly for the harvest, it was possible to employ people for longer. Again, this was considered a temporary measure. Slaughterhouses became a COVID-19 hotspot in Germany because lots of people work close to each other. It's a high noise level, so people raise their voice or they shout even at each other to be understood. And also the low temperature seemed to benefit the survival of the virus. And because it's a refrigerated environment or cooled environment, it's a closed space which also has poor ventilation. And what was a big scandal in Germany was the living conditions of contract workers who stay in very crowded accommodations of poor quality. And there were pictures also from people who got in quarantines, or a whole block where they lived got quarantined and they couldn't leave basically the place for 2 weeks. And that was quite a sad story, and a big discussion kicked off about the working conditions. And now we are approaching a ban on these contract work to a large degree in the meat sector because of that. Yeah, very briefly, contractual obligations and insurance cover discussion. So who bears the risk that of impossibility of performance? Force majeure is something that is known from international contracts very much. We do not have this construct in the German contract law, at least not in our civil code. And if you have it included in your contract, it's always this question of whether it is an unforeseeable, significant change of circumstances. And most in literature, most authors assume that contracts that are entered into after end of January 2020 could not invoke this unforeseeable significant change anymore, because at that time it was already clear that the COVID-19 pandemic was coming. Also, if you another option is to say we exclude the duty of performance because of impossibility, because you cannot deliver, you cannot provide the service. But then the question is, when is performance impossible? Is it only a temporary impossibility? And to what level is the liable party obliged to obtain the outstanding goods from somewhere else, or even be it at a higher cost? Interference with the basis of transaction is also an element of the German Civil Code. Then it must be something that is outside the debtor's area of responsibility, and it must be gross disparity between the value of the good and service and the consideration, and that would lead to the inadequacy of the obligation. But that's also a construct that can only be very rarely invoked. Insurance cover for business disruption, that was a highly contested area. Some insurers just offered a 15% lump sum payment against waiver of any further claims to get rid of these claims and procedures. But it really depends on the individual policies and what is stated there about infectious diseases. And the other one is the question, what is closed by official order? What means closed by official order? So there was also clarified by the courts that individual orders by the authority and individual establishment are the same as closures ordered by a regulation which affects multiple establishments. And full closure of business can be assumed for restaurants, even if they can serve, can offer to-go sales or takeaway, if those takeaway measure business is not commercially viable. Yeah, now just briefly the outlook. The changing consumer behavior may be one of the major drivers or things that will stay, that people started to increase their online shopping of foods, and they will, on the other hand, they also buy more in their local shops, short distances, support their local businesses. So it's two more or less contradicting movements, but that may have some consequences in the future also for big shopping centers, shopping malls, and the like. Yeah, now I'm at my conclusions. What you see is that the COVID-19 pandemic highlighted a vulnerability of the globalized agri-food chain by factors that go beyond the classic food safety issues. It was always about food safety in the past, but now we see that's also a pandemic can create significant disturbances and even put food security at risk if we go to the extreme. And so food security and sustainability probably will be some areas that more focus has to be on in the future in the agri-food law. And we have seen a bit of that already with the recent proposals of the European Commission. But maybe from the experiences that we now have gathered in this pandemic, might be worthwhile to refine them still a little bit and make them more future-proof than they are now. Yeah, I hope I could give you a bit of an insight in the German situation, and thank you very much for your attention. And I would like to hand over back to Ferdinando as the chair. Thank you very much.
Dear Martin, thank you really for this important, significant presentation. I listened with great attention to all the points, but there are some points that just went in my attention. One is the judicial decision regarding chocolate and wines, recognized as part of essential food. And this is part of a much larger discussion that we are just starting today. I'm so sorry that the time that each speaker has is so short, but we are just starting to speak on this. So food is also pleasure, we know. And so this is part of the consideration of the judicial decision. Secondly, stockpiling. And this is another really relevant point. We didn't have this experience in Italy, but I can imagine, I've seen some photos from the United States. I didn't know that even in Germany, there was this problem. And a third point, I was asking to all the speakers, what do you think about responsibility and governance? And when I heard from your speech that Germany closed the border with a series of countries, but not with Belgium and Netherlands, while Belgium had a large number. This is also a matter of establishing who is in charge of what, which is a big question for Europe. And finally, what I share from your speech is the conclusion, but I have a question. You concluded saying that looking to this story with the pandemic experience is some sort of having magnifying glasses. I totally agree on this. But then the point is we need a more sustainable agri-food system. The question is, what is the meaning of sustainable? I'm not so sure that we all agree on it, and we will see in the next few months. So thank you again. And now I ask to Edison Tang from Shanghai to take the word. I thank him very, very much. I know it's very late in the evening, and we are very pleased to have Edison and the other colleagues from Shanghai together with us at this time, just to share ideas, proposals, and then future tasks. And he is from the Food and Drug Safety Association, and will speak us on China new rules for agricultural products in COVID-19, a newly enforced certification system. This is one of the really sensitive topics. I just gave a few elements in the opening speech that these of the control and certification, a really serious one. So thank you very much, Edison. I am silent and I give you the word.
Thank you. Thank you for the invitation, and thank you for the nice introduction, Professor. Do I need to share the screen so that you can see it? Hi, everybody. I'm Edison, and I'm from the Shanghai Food and Drug Safety Research Association. And our organization is a government think tank who is funded by the China FDA. And our primary role is to advise the lawmakers and the enforcement agency on how to implement the food laws and standards. And today I hope to talk about a newly enforced certificate system on the agricultural products. It's kind of a new innovative legal tool in this difficult time. I would give some brief introduction about the certificate system and also the challenger we are facing. And we have a resurgence in Beijing, and I will share that case and what they are doing. And as COVID-19 is not familiar to us, it has been surrounding and haunting us for about a year, right? Almost a year. And we know we have the first case in a Chinese city, and it's in December. And it was in a seafood market. At that time, it already reminds our FDA and the authorities that the farmers market or seafood market is very easy to be the target of this virus. And the Chinese are very obedient, so they go everywhere wearing the masks. So we don't have a very serious resurgence. We only have one big substantial resurgence was in Beijing. It was in June, and we found over 300 cases. And the source is from the imported salmon. So we know the virus could survive through the cold chain transportation. It's just like the Professor Holai said in his presentation that maybe the virus survives the colder environment. So both cases can alert the China FDA that the farmers market, the seafood market, grocery store, and everything related with agricultural products should be regulated because it's a high risk area. And so we just expedite the implementation of this certificate system. It's just like give an ID card for the agricultural product. When you read the mark, you will understand what this producer and some basic facts or information about an agricultural product. And legally speaking, we call it's also to strengthen the first-person responsibility. What do you mean by the first-person responsibility? It's retailers, distributors, they all want to shift all the legal liabilities to the food producers and the farmers because they think they are manufacturing or growing the products. So they should take the first and the primary responsibilities. In the Chinese legal system, we call it the first-person responsibilities. China FDA also wants to confirm that the food producers and the farmers should take the first responsibility, but they're also worried about without a proper help, the small farmers, the small business cannot survive. And for this certificate system, because it includes a lot of information, so it will get more transparent, and it's good for the traceability, and the consumers can get to know who is a farmer, who is a producer, and the retailer, distributor, and all this kind of information. It's good for the consumers, right, to know. And for the government, for the FDA, by collect this data, so we will know more about the safety and quality of the agricultural products. And the China FDA cannot rely on everything on the self-discipline. So they will do the flight inspections, and they will visit the farms, they will visit the retailer stores, and to see if they have actually implemented certification mark systems. This certificate mark is different from other marks. We have a lot of certification marks in China. Some are issued by the trade association, some are issued by the third-party agency, and like the organic or green food and pollution-free. But this one is different. This one is only about food safety. This certificate mark only includes their commitment and warranty about the food safety, nothing about the food quality. And actually, this certificate system is not new. We can trace it back to the 2012, and they were discussing about to have a certificate system on the agricultural products. At that time, the purpose is to solve the issues on the cross-province tradings. In the big cities, the consumers are very picky. They want the natural food. They want the high quality foods, but they worried about the food safety. At that time, for example, the yak milk, it's in Tibet, and it's very natural, and people believe it's high quality and nutritious, but they are worried about its safety because the yak are raised by the small farmers or small business. So they want to have a certification mark so that people will know how to raise a yak, and they will get more information. And the China FDA has tried out in 6 provinces and since 2016. And now in this year, we have a countrywide implementation. But here we have the guideline about how to implement the certificate system on the agricultural products, but there is no written law in our Congress, passed by our Congress, saying that this certification on the agricultural products is mandatory. So the food industry and the China FDA is waiting for the Congress to pass the law. So quality and the safety law of agricultural products, it is already a draft for comments and the Congress is reviewing that. So we have a guideline in place, but we don't have a written law to confirm it's compulsory to the industry. And for the COVID-19, people change their behavior, especially on their shopping patterns. And you will say there is a rapid growing demand for the online shopping and people can buy vegetables and meat, seafood at home. And you know, the efficiency of China's logistic way, you can get the fresh vegetables in 30 minutes after you make the order. So it's very, very quick. And the point of sale platforms like Alibaba and other online giants, they ask the supply chain to mandatory implement the certification mark systems. And so in the first 3 months of 2020, already 32 million certifications are issued. It includes the small and big business. And they also encourage the farmers and the producers or the family farms to do the same certifications as well. Also, it is the mandatory requirement that all agricultural foods to the epidemic areas should be certificated. And we have a resurgence in Beijing, and it's like over 300 cases. It's already very huge in China. Beijing FDA has no experience on how to control ensure the food safety on agricultural products during a pandemic, but they really have experience on how to control the movement of people in a pandemic, because we have the SARS in 2003. So they take the same, follow the same pattern as what we did in the 2003. So the citizen will have a health code and in your cell phone, and you should upload all your information, including your names and your travel paths and what places you have been, and submit to this system. And they will see if you can get a green code. The green code is the only pass for you to visit any public places like the cinema, the farmers markets, the supermarkets. And the information is provided by the users, but there are some verification systems, like the public places owners, like the supermarkets, they will have some servicemen to verify whether all the information are true. And also the government can use the big data comparison or the flight check to see if the information submitted are authentic. And they take the same method when they regulating the agricultural products. They ask all the farmers to issue a certification mark and provide their information. And also, they have the distributors and the retailers to review all the information to make sure there's no forced certification. And also the government or the third-party service provider can help to check the data and to make sure there's no massive forced certification uploaded. But as it is a new tour in China, so we still face a lot of challenges. The first one is about what commitment the small farmers and the small business are comfortable to make. And they can make about they don't have any pesticide, they satisfy the requirement on the pesticide residue because it is a mandatory law. And they also can make the commitment that they have not put any illegal additives to the agricultural products they are selling. And it's basically the human factors, so they can control that. But the consumers have a higher expectation. They want you to make sure there's no residue of heavy metals, have the contamination of biotoxin. But the small business and the farmers are reluctant to make such a commitment because they think it's about the environment and they don't have an in-house lab to test that. So they hope they can only make the commitment limited to the pesticide residue or illegal additives that they can control. And so the China FDA is discussing how to make the commitments. What is the scope of this commitment that small farmers can afford? And the second is about who are the subject of these implementations. The big online platforms, like the point of sale platforms, they can satisfy this requirement, and they also can enact the private standard to ask all their supply chains to follow this practice. And how about the small farmers? We have a lot of small farmers, but maybe they can't if without the proper help. And the China FDA will do the education to these small farmers or the small business, and to tell them the responsibility, and to tell them it's a law requirements. It's not something optional, it's mandatory. And they also give them some advice on how to create a certification mark and what information is necessary on these marks for the consumers to know. And at the other hand, they also need to do some consumer educations. For the Chinese consumers, in most cases, they are picking the vegetables and all the agricultural products by taking a look at the appearance and feel their sensory feelings, and they don't really read the marks. It's not like the branded foods, they will read all the labels, but for the agricultural products, everyone is expert. They don't want to read the mark, but the China FDA wants to make sure they read the mark so that this certificate system is not a waste of resources. And also, the China FDA faced a challenge on the cross-department cooperation with the lawmakers, the Agriculture Department. Agriculture Department makes all the guidelines and the rules, and the China FDA is the enforcement agency, because the China Agriculture Department, they don't have the local offices. It's not like the FDA, they have both the state offices and also the local offices in every district. And so it's sometimes they have the different perspectives on the same issues. So they need to have some cross-department cooperations. And also the China FDA also regulates the food. So they will follow the standards made by the China Health Department. So they were thinking about, they also need to make sure there's no big conflicts between their practice when regulating the food and the agricultural products. And I have mentioned about the legal status is that we already have a guideline in place to let the industry know how to implement the certificate system, but actually we don't have a law passed by the Congress to confirm it is mandatory. So we are waiting for the Congress to pass this law. And also in this guideline, we don't have a legal sanctions. So we are thinking about how to incorporate the legal sanction in this quality and safety law of the agricultural products. And we want to have a heavy legal sanction like the China food safety law, but we also worried about if the small business, small farmers can afford that. And we don't allow if they can't afford that, maybe they will trigger the idea of doing massive force or fake certifications. Then the consumer will lose the trust on this certification. So we also want to give some legal obligations for distributors and the online platforms. But what are their legal obligations should be? Can they get a joint liability? I don't think so, because in this guideline, we have explicitly established that the first and the primary responsibilities on the producers and on the farmers. So they can't join a liability. But for the distributors and the retailers, they have more resources. So what is their duty of care? How can do they just need to review the documentation and they will be fine? This is the China FDA is thinking about. And also they are thinking about to have a uniform format for the different provinces and for all the farmers to use the same format. Then it's easy for them to do the big data monitoring and for the database. But China is a big country with imbalanced economic development. For the coastal cities along the southeast China, they can accept a very complicated format with a tracking code or some technology tool, and to have a full comparison, transparency to the consumers. But for the rural or underdeveloped areas, maybe they can't afford a too complicated uniform format. So China FDA is also working the industry on what kind of format is at a necessary basis that the most farmers and the small business can also accept. This is my sharing piece, and thank you for the time. And I hope it is intriguing to the participants. Thank you.
Oh, dear Edison, thank you very much for your really interesting presentation. And we see that in fact, even with very different legal systems, we are sharing some problems and in some way, even some solutions. And you say, what about small farmers? And this is the same question that we have in our system. When we are speaking about direct sales or short chain sales, what is the guarantee? What are the tools to give these guarantees? And these are the central questions. I also found really interesting from a comparative point of view that at the moment, there is no legal sanctions, but just a system which is based on participation of small farmers. We discussed those topics even 2 years ago in Trento, and you and your colleagues were speaking about the new system of local community responsibility in charging this sort of problems. I think that, again, as Martin said, in some way, this pandemic situation is a sort of amplifying glasses. So we are forced to look to problems which we already had to deal with new lenses and find new solutions. And the solution of a voluntary obedience to the system is a very interesting one. And I think that we must spend some time more in the next future to work on it and to see how we can share the system and how we can bother and in some way use it. So thank you very much again. And as I already told to the participants, anyone who is interested to know more elements on the German situation or the Chinese situation can write an email to the Secretary of the Italian Food Law Association, and we will share with the speakers. Nowadays, I ask to our technicians to send the speech recorded from Professor Michael Roberts from the UCLA University in Los Angeles, and he's going to speak about the US experience during those months. Thank you very much.
Buongiorno, my friends. From Los Angeles, it's nice to see all of you today, and I hope that you are all well and safe. My name is Michael Roberts. I am the Executive Director of the Resnick Center for Food Law and Policy and a professor from practice here at UCLA School of Law. My topic today is titled on my screen, How Law and Governance Can Facilitate the Harnessing of Innovation to Build Resiliency in the Food Supply Chain. If you don't mind, I would like to at least take some personal discretion here and tell you how much I miss Italy. I've been to Italy many, many times and enjoy lots of friendships there. And it's just a shame that I haven't been able to go back in recent months. This is a picture of my spouse, whose family is from Lucca. Her grandparents are both from Lucca. And she was taking a cooking class just a few years ago in Florence, and we really miss our family and friends there in Lucca. Of course, I miss my dear friend Ferdinando Abbassini. Professor Abbassini and I are seated here in a picture outside of Rome, and then a picture of myself at the FAO in Rome with Graziana da Silva, the outgoing FAO director, when we were able to negotiate and agree upon a partnership between the law school here at UCLA and FAO on a number of different initiatives and projects that involve our center. So I do miss Italy and hope to rejoin you very soon. Now, back to the talk on point here in today's session. The Resnick Center provides cutting-edge legal research and scholarship in food law and policy to improve the quality of life for humans and the planet. In doing so, we do three things. We research and engage in scholarship. Secondly, we engage in leadership development and teaching of students. And finally, we perform outreach, convening and collaboration activities. And so I'm grateful to be here with all of you to talk about this very important topic of COVID-19 and its effect on the food system, especially here in the United States. Something I remind my colleagues here in the United States often is to think about food law as a multi-doctrinal discipline, one that applies to different types of legal issues that are born out of a modern food system that we have not seen the likes of in the history of this world. And it's the application of law that makes food law so distinct, because it really is applying legal doctrine and laws and policies to these problems, or to, in some cases, changing social norms. To that end, the question we ask ourselves today is, what is the application of law to COVID-19, or how should law respond to COVID-19? And as we look at our respective countries, I think we see a fair amount of overlap and some interesting ideas on how to use law as a strategy or as a tool in this regard. Here at the law school at UCLA, we've put together a COVID-19 and food law library that our students are currently populating with a number of articles and other important manuscripts that will be used by scholars and researchers in examining COVID-19 and food law and its and the application of law to COVID-19. We can all agree that there has been sufficient evidence of disruption due to COVID-19 in our food systems. These range from food shortages to price gouging to restaurant closures, which has hit my community here in California particularly hard, food safety issues, worker safety issues, even more importantly, and nutrition. These headlines of disruption certainly have created a stir, not just in the United States, but all over the world, as these headlines from around the world show a common concern of food security issues. It's also interesting to look at the marketplace and the shifts in consumer behavior and attitudes towards food because of COVID-19. I gave a talk recently at the Food Drug Law Institute by Zoom in Washington, D.C. on this topic. And there was an article in the ADM on 6 different behavior shifts in face of COVID-19 that I thought it would be interesting just to share with you briefly. An increasing focus on gut health and immune function. Plant-based has become mainstream and in some cases has exploded in its sales through COVID-19 as an alternative to meat. A new perspective on weight management and metabolic health. finding balance of self-care, emotional well-being, and nutrition, things that people think about when they're at home. Personalizing nutrition has been a really significant response as people look for ways to personalize nutrition to their diet and health plans. And finally, a shift in shopping values. The question, of course, is, are these shifts durable? What is the impact on food supply lines, the impact on law, and even the impact on the delivery of legal services? This is just an illustration of how nuanced and how complicated and interesting this examination of the response of law, particularly food law, to COVID-19. Certainly, there are a number of legal responses here in the United States with respect to COVID. An enormous amount of guidance from the FDA has been issued. I have to compliment the Food and Drug Administration for its broad scope in guidance to consumers and to the food industry as a result of COVID and disruptions in the food supply chain. Inspections certainly were impacted. They were postponed in March and then resumed in July as a part of Trump's opening up America again. Claims, a number of claims have been made on food products, especially dietary and more novel products. And these claims have been reviewed, scrutinized, and in some cases, there have been warning letters issued by the FDA and the FTC, the Federal Trade Commission, which regulates advertising of food. The FDA's jurisdiction covers labeling of food, and this is via a memorandum of understanding between the two agencies. Other interesting legal responses are liability shields for employers, such as was argued in a Tyson case, a Tyson being the large protein or meat manufacturer, and relying on guidelines issued by the Trump administration that arguably created a shield for employers. All of this is being litigated, and there's some interesting decisions that have been handed down and yet to be handed down. States have responded to price gouging through legislation and in some cases through enforcement action. And of course, this gouging covers not just food products, but particularly focused on food products such as eggs and other products more susceptible to price changes. And finally, interestingly enough, the great American tradition of class action litigation. I've had a question as to how COVID might impact class action litigation, which generally in the U.S. has to do with labels in advertising. My understanding is it hasn't had much impact at all, and that this litigation seems to be continuing with full force ahead. But I do think it's also helpful to not just look at these specific responses, but to take a step back and to look at a concern that the U.S. has or should have that's shared with other countries around the world. In most countries, and I focus a lot of my attention on international food law and how different, and comparisons of different regulatory regimes. And it's safe to say that most countries are beset by fragmentation in the regulation of food. Also, a lack of coherent, overarching governance strategy connected to the health of humans and to all species and the planet. And this predicament, these shortcomings that are prevalent throughout the world, can leave the food supply chain, or I prefer to call it a maze, susceptible to disruption. And what that does is that creates a situation where we need to focus on the critical rule of law and governance on food systems work. Now, in a more particular way of saying this, the question is, how can food law scholarship and food law in and of itself build resiliency in the food supply chain to counter current and future sudden disruptions? Our attention is focused on COVID-19, but there are other pandemics as well as climate change and trade wars and even major food safety outbreaks. The overarching focus, it seems to me, as we look at this overarching issue, is how best to meet the needs of those most vulnerable and susceptible to hunger, suffering, and food justice, which puts food law squarely into a mission-driven focus, but one I think that most of us are very comfortable with. This step back also requires us to examine the different governance models, many of which coexist in countries to varying degrees. These models, a sample here I was put on this slide, include command and control or direct regulation, self-governance, which arguably the industry wants to assume can replace government regulation to some extent by allowing companies to build private standards, for example, and other approaches to self-governance, association standards, managing supply chains through private contract. Another governance model is co-regulation, where industry and government work together to create efficiencies, and in some cases to improve policy and to improve lawmaking. We see this, for example, in the United States with the FDA's recent issuance of a smart governance or smart food safety regulation that reflects the thinking that there can be, again, a relationship between industry and government working together, which is really the model of the Food Safety Modernization Act by the United States back in 2011, which is to require industry to take preventive measures to ensure food safety. And then finally, a fourth one that I think is most interesting is social governance. And this is, of course, a concept that was the basis of food regulation in China, starting back with the 2015 food safety law and then reinforced in the 2018 regulations in China. And it really is an interesting concept, one that creates expectations for compliance with various stakeholders, including even the media and consumers, as well as industry. So all of these are very interesting concepts working in different ways. Underlying these models, it occurs to me that we live in an era that's very interesting, a transformative era because of technology and other changes in our environment, political and cultural environment. And it does sort of beg the question as to the role of sharing and competition and the tension between these two concepts. And as well as the role of technology and thoughtful collaboration and how these things can work together hand in hand. Speaking of sharing, I've been working on a studying for a part-time doctorate at Oxford University in history, looking at the historical development of the international regulation of food. It may a more realistic way of saying it are pathways not taken. But nevertheless, there was a really interesting idea that was floated by Sir John Boyd Orr, the first director of FAO for the United Nations, of a World Food Board that I won't take time to explain in too much detail here today, but to mention that the predicate really was to ensure enough food for people to eradicate hunger and even malnutrition, but to also rely upon cooperation and cooperative endeavors to create equality and other norms that at that time seemed important after a major war. This idea was nixed. It was in favor of a more free trade approach advocated by the US and the UK. But it's interesting to think about these concepts, and they're not new, they've been around for a while. As I frame these norms and these ideas into possibilities, thinking about ways that innovation and technology in the US and other countries that are often driven by need, and certainly COVID-19 is a driver at this point. We think about production. how can we better produce food? What are innovative approaches that create resiliency in our food supply? Accessibility, which often is an overlooked point of problem solving, creating accessible pathways for peoples to get food. Delivery of food, which has become, of course, driven by technology, as our friends in China, as our friends in Europe, as our friends in the United States all can attest to. And then finally, information. What are the possibilities of conveying information to consumers about food in terms of nutrition, the environment, and if you remember, as I said earlier in my presentation, talking about trend lines to personalized nutrition, personalized diets, personalized approaches to acquiring information about food. All very interesting possibilities. Of course, possibilities need strategies and they need tools, and this is where the law can step in. But as we think about these tools and these strategies, there's a range of them. And again, I list these on the screen. Digitalization, the conveyance of information, and even detailed packages to consumers, to industry, to government officials. Blockchain, the ability to create transparency and to ensure that we have supply chains that we can tell what's going on when there is a disruption, and that can be most helpful. Automation, replacing the workers who seem to be a fragile part of the supply chain with robots. Of course, this comes at a cost, a human cost, when we deal with issues of employment and labor and human dignity as it relates to food. The plant-based movement, again, another novel strategy and tool that's emerging that can create some sense of stability in the food supply chain, or at least offer a different alternative to protein. The next two actually interest me the most, or at least not necessarily the most, but in terms of the ability of law to help engineer, and that would include local solutions. Arguably, the consolidation of agriculture and food have made the supply chains less stable, more susceptible to disruption. We saw that in the United States, for example, when workers became ill at meat packing facilities and meat processing facilities, that it essentially shut down the meat industry and created a panic in the United States. When Tyson was forced to shut down its operations, it wasn't too long thereafter that the CEO of Tyson's announced that there was going to be a food shortage and hit all the major headline newspapers. This, of course, wasn't true. There was plenty of other types of food to consume. But the point being that consolidation in some cases can create a problem of supply when we look at especially major disruptions in that supply line. And so an argument could be made that local solutions, which is not a new idea, but perhaps COVID is a way of accelerating that forward. Some of the newer ideas, though, about local solutions get us into the area of what we could call controlled environmental agriculture or vertical farms, ways of developing local farming solutions. And how does the law work in this area? Well, certainly in the United States, we talk about zoning issues. We talk about working with local authorities and building incentives and tax incentives and property incentives and distribution channels and so forth. These are all interesting ideas that are being percolated around the different universities and community groups and even amongst policymakers that I think have some real potential. And then finally, ideas or strategies related to regenerative agriculture, food loss, and genetic engineering or other types of technologies that I know can be controversial depending on which country we're in at the time. But the point being that there's a number of different genetic engineering or nanotechnology and different kinds of technologies that all relate, I think, importantly, not just to COVID concerns, but even more importantly to climate change. And so these are different strategies and tools, and it's interesting to think about the approach of the law to each of them. So when we think about these considerations, the opportunity to apply a legal response to a problem, what's the governance model that we're working with? What are the strategies and tools? Another important concept is the incubator concept. One of the advantages of doing things on a local basis, you create an incubator effect where you can experiment and test the effects. The outcome of all of this, of course, are novel approaches to disruption, including COVID-19, that are holistic and integrated. They're not just relying on law, but they're also relying on science and other types of disciplines that have to weave in order to create real solutions. And I think, lastly, again, the sharing of information, which is a critical part of working together in a new frontier of environmental concerns and technological capabilities. Is how do we share information to the betterment of everyone? So this is an exciting time, as well as a frightening time, to be part of food law and to recognize not only the challenges but the opportunities, some of which I've seen occur in the United States and in other countries. But hopefully we can all continue to share, learn from them, and help better the lives of those around us, and certainly help improve the food systems around the world. So thank you for your time. It's nice to see all of you again. I hope to see you in person sometime soon. Bye-bye.
I think that all of us really appreciated this significant speech from Michael Roberts. It is a pity that he can be with us today to discuss later and further the point that he raised. But in fact, what is really interesting, it is a confirmation of the use of the comparative method, that even in a reality which is so different from the economic point of view, from the organization of agriculture, from the rules and institutions, we have many points that we share. And I found really of interest and a confirmation of the real basis on which we organize this Congress, that starting from food, the final considerations are all related to agriculture. And he made even a mention on genetic innovation. Tomorrow morning, at the end of the morning, we will speak even about this innovation and genetic innovation. But there is another problem which is really interesting, and it is another suggestion that I think we can share with the experience from the United States. It is this one of looking about sharing information. This is the central point. It's the point that is in some way common to the different speeches that we listened to this afternoon. The experience made in China, the new experience in the United States, the new role of FDA that is also sharing decisions with industry. So the role of the public institutions is changing. We are looking to the emergence of a sort of cooperative system. And it was interesting that this sort of cooperative system is emerging even in China and in the United States, and Michael Roberts made some comparison on this. So it is a problem of social governance. Another confirmation of this, that the food system is an agri-food system, and this is also a problem of social general responsibility. I think even on that, I'm very grateful that I just listened with great interest to this US experience. And nowadays, I will ask to the service to send us the speech from Theodore Georgopoulos. Theodore Georgopoulos is a distinguished lawyer. He works in the University of Reims. He's of Greek origin. He works mostly in the area of wine law in Reims, in the center of the Champagne region. And what he will discuss with us is emergency of wine law in France under COVID is anything more definitive than the temporary? This is the question that Theodore Georgopoulos puts to us, and I think it's the same question that we are putting to ourselves. What will be the next future, even when the pandemic emergency will be finished? So I will be grateful if the offices can send speech of Georgopoulos. Thank you very much.
Good morning to everybody. I'm Theodore Georgopoulos, and I would like to thank the Italian Association on Food Law for this invitation, and especially Professor Ferdinando Albisini for inviting me to talk about the consequences of COVID-19 and the pandemic in the French wine sector, especially from a legal perspective. It is true that it is a question of great importance given the value created by the wine sector for France, and also France being one of the major players together with Italy and Spain with regard to the regulatory framework in the EU related to wine. It is true that it is a question of the utmost importance, but at the same time, it is a question that it's evolving. Since last spring, there have been quite a lot of different issues, legal issues that have been discussed, and still things are evolving. So what I would like to briefly present today, it would rather be as a diagnosis of the questions and the problems that are related to the pandemic, the impact of the pandemic in the regulatory framework for the wine sector in France. And of course, I will also discuss a little bit the therapy, but still I think that it is too early to discuss about the real impact on the long run of this pandemic. However, what is clear is that we're talking about emergency law. We're talking about a state of emergency that has changed quite a bit the habits, the procedures, and also a certain number of certainties related to the way wine is produced, distributed, and consumed in France, but also in the whole European Union and even beyond. When we're talking about a state of emergency and emergency law, we're talking about something that it's urgent, it is exceptional, and it also has a temporary character. I would like to stick to the urgent and the exceptional character, and we'll see, and as a question, if this emergency, the state of emergency, has a temporary character as far as we can predict it today. But before we discuss this question, there is a paradox that I would like to stress, which is probably also underlined by other speakers today. COVID-19 is not related from a pure medical point of view to the consumption of wine. Wine is not infected by COVID-19, and there is no correlation from a medical point of view between consumption of wine and consequences of COVID-19. However, both production and consumption of wine have been under important pressure, which has asked for solutions that come from both from the national and the European levels. Now, what has been under pressure more precisely? I said that we're talking about a state of emergency. In a state of emergency, what is important is that rules and relations, balances that have been established are under question and under pressure, and even under evolution and change. Balances that have been pillars of the wine sector in France that are under pressure today. Let me give you a few examples. First, the balance between the EU and the member states. For many years, especially since the Europeanization of the wine sector and its regulatory system, which, as you know, is an ongoing process that started in the 70s, but was especially after 2008 and the regulation 479 that this Europeanization has become a real established European regulatory autonomous system that has replaced, to a certain extent, national ones. Since 2008, we're having a new balance between the EU and the member states, with the European Union rather being the one that leads, and the member states, including France, that rather execute with a concern for local specificities. Well, this balance is about to change. Let me remind you that on April 30, 2020, we had a certain number of regulations that changed completely this power allocation of powers between the EU and the member states. A lot of derogations and exceptions have been introduced, accepted, and if there is one word to describe these rules that have been enforced by the European Commission through executive regulations in order to deal with the consequence of the pandemic, that word would be renationalization of the wine sector. I strongly believe, by reading these regulations, that there is a clear, swift, and a change of the center of gravity again towards the member states. This is from both a regulatory and a financial point of view. From a regulatory point of view, there have been quite a lot of margin of appreciation that has been left to the member states, including France, to find solutions and to be able to deal according to their needs, to the standards, and also to the impact of the pandemic on the wine sector, find their own solutions. From a financial point of view, the funding is strongly now based on national funds, or at least there was no special aid that has been allocated to the member states. Maybe the only thing that was done, the member states were given the power to proceed to a new sharing of the available European funds for the wine sector, which means that in fact it's up to the member states, and France has taken measures at the governmental level in order to deal with the consequences and help the producers, either in terms of crisis distillation, in terms of green harvest, or in terms of funding of the storage of wine. There were also other measures of pure national character, like the exemption from the payment of social security charges for the temporary workers during the harvest, and also some tax credit advantages for wineries that were under the pandemic meeting up standards of high environmental value. So these measures have been considered by the European Commission as exemptions to the general regime of state aid. In any case, we see through these examples that it's no longer a matter of allowing, of having a strict control on the member states that must follow the general policy of the European Commission and the European Union with regard to the common organization of the market. Of course, I'm not saying that the common organization of the market is let's say, under a major crisis, but I'm simply saying that under this pressure, under this emergency law, we see that we go back to national solutions, and that the European Commission preferred having to step back and let the member states find their own solutions. Another balance, so that this was a question of the balance between the member states and the EU. Another balance that is at stake and under ongoing pressure and change during the pandemic, it's the balance between producers and distributors. Now here, always in the same logic and method of finding national and even local solutions, we're having the readjustment of the market, especially through the adjustment of the yield in the PDO and PGI zones. An example is the example of Champagne, where the yield for this year, for 2020, has been under common agreement, has been readjusted in order to, let's say, give an answer and reply to the decrease of consumption of Champagne this year. So we're having here an element that is quite interesting because we are also putting under pressure the flexibility of the product specification, the disciplinare as we call it in Italian, or the cahier des charges as we call it in French. So more and more we have seen flexibility with regard to the rules of the product specification, in case of emergency, but mainly with regard to climate conditions. But this time we're talking about flexibility with regard to economic emergency related this time to the pandemic. We had quite a lot of examples. I just gave you the example about the yield. There are also examples where there have been specific rules that have been imposed in order to allow to specific zones of PDO wines like Baume de Venise and Queyranne in France to be able to use machines for the harvest, which is normally not allowed according to the product specification. The rules of regulation, the executive regulation 33 of 2019, that allow temporary changes to readjustments to the rules of the product specification have obtained a new meaning, and this is also something to be taken into account. And by all means, the performance of the wine sector at the local and at the national level, this is what the French example shows. This performance will depend also on the possibility of the wine law and wine regulations to be adjustable, to be flexible in case of emergency. Last but not least, there is another kind of balance that has been at stake, and that it's probably the most important, that goes beyond the consequences of a temporary state of emergency. And it's the balance between free trade and alcohol consumption. As I said at the beginning of this short presentation, normally there is no correlation, there's no relationship scientifically established between consumption of alcohol and the pandemic. However, given the social consequences of the pandemic and of the measures that are taken in order to deal with the pandemic, I'm talking about the lockdown, I'm talking about the problems related to the economic recession, there has been a lot of discussion, and measures have been taken, especially at the local level, in order to ensure that alcohol consumption will remain under strict control. You are aware that in France this is already a big discussion since 1991 with the Loi Vin that enforces a very, very strict regulatory framework with regard to advertisement of alcohol. Well, in this case, we are having measures that go beyond prohibition of advertisement. We're talking about real prohibitionist trends with regard to consumptions of alcohol. They have been decreased at the local level, where municipalities have tried the experiment of the prohibition of sales and consumption of alcohol even beyond the lockdowns, at specific hours or in the center of the city. Of course, this does not mean much, because one might say these are temporary measures that can be justified given the pressure, the psychological, the economic, the social pressure under which we're all in these dark hours. However, I believe that there is much more to be left, I would say, as a heritage of this pandemic at the level of the discussion, and maybe at the level of the regulations of tomorrow with regard to alcohol consumption. I believe that our societies in France, but also elsewhere in Europe, are going to be much more sensitive in questions related to control of alcohol consumption, because our societies, after the pandemic, the day after when all this is gone, our societies are going to be much more sensitive with regard to health issues, which of course is not a bad thing as such. The only thing is, how far will these new trends go, and what kind of measures will be justified at the regulatory framework based on the name, let's say, of public health. I strongly believe that these kind of regulatory measures that are taken on to the local level are likely to be tomorrow's, let's say, matrix for rules that will go far beyond what is today known as small, strict, and quite marginal regulations with regard to alcohol consumption. Of course, no one can really say how far we can go with this. However, this is one important point that needs to be stressed, which is a matter of law, but also a matter of political science, that by all means, the day after the pandemic of COVID-19, we will have to expect, by all means, new rules, maybe at the European level, but in any case, I talked about renationalization of the wine sector and the alcohol sector in general. We will have, by all means, at least at the national level, much stricter rules, permanent rules. So actually, this is I guess this is the most important conclusion that I would like to deliver to your judgment, and that is likely to contribute to the public debate about the consequences of the pandemic, which is, in fact, since we're talking about emergency law, we're talking about urgent law, we're talking about exceptional law, and we're also talking normally about temporary law. And this last element, the temporary character of our rules, is something I really doubt that is to be taken for granted. I strongly believe that after the pandemic, which I hope, just like all of us, will end up soon, is likely to change specific aspects, especially with regard to alcohol consumption, forever. Thank you very much for your attention, and hopefully next time I'll be able to be with you and share a glass of wine. Thank you very much.
So I think we are getting some precious contributions on the path that we decided to pass through today. And I just want to, to underline some final points. This morning, Irene Camphor, Anthony and Areli spoke about that recent book on il diritto all'eccezione, the rule and the exception. And the same problem is coming out from the very interesting speech from Professor Georgopoulos. I'm just leaving aside for a while the problem of the rules regarding the alcohol and the wines, but my attention was really captured up by the consideration of what is going on with reference to the relation between European institutions and national powers with reference to wine law. We had this experience, this very significant reform in 2008, and the center was transferred from member states to EU. And nowadays we are seeing from many specific implementing regulations. So these are binding rules, these are hard law, these are not only political documents which are giving back the power, the decisional power to the member states. This goes back to the central topic that we are discussing, not going to discuss, that we are discussing during this meeting. Where is now the responsibility? And a second consideration that I think I personally share in what Theodore said is, okay, we are now dealing with an emergency, and these measures are justified because it is urgent, it is exceptional, but are they going to be temporary? And he made some examples regarding the bylaws for wines, even famous wines like champagne. We can make some examples regarding the Italian PDO and PGI. As I just made you a few examples in the introductory speech, there is the example of the milk which can be frozen for the mozzarella di bufala campana, which was not allowed. But we had even changes for Morellino ex Scansano. We had changes for prosciutto di Parma, finocchione, prosciutto toscano, Tuscany ham, and so on. So the trend is that to reshape the point of decision, the point of governance, more near to the land, to the territory where it is going to be applied. And this is really significant if you look to the food production, because this is going back really to the land, to the agricultural production, to the producers which are called to be responsible for what they do. I was just listening with interest on the problem of use of machineries in vineyards and so on. And you know, there are other things like that which are under discussion today. So again, look into the experience of very near countries like France may be interesting and enriching for our discussions. Nowadays, we are ready to go on the other side of the ocean, and we are just going to listen to Professor Cloutier of the Université du Québec, and he's going to speak us about exogenous shocks to the Canadian agri-food system and the COVID pandemic, retrospective and prospective issues. This is the point. We are just reasoning, of course, with legal tools, because we are speaking about new legal tools that are going to be adapted. But these tools are not only tools regarding single rules, single aspects, but are tools regarding even distribution of power. And from many of the speeches we had just today, a first confirmation that the idea is now to redistribute the power and the responsibility and the governance. So please, Professor Martin Cloutier, this is up to you. Thank you.
Thank you very much, Ferdinando, for the invitation. And I would like to extend my thanks to Matteo Ferrari as well for having me with you today. Like many of my colleagues, I would have preferred to be there with you in person, as this was the case 2 years ago in Trento. But it's my pleasure to be able to communicate this way, and hopefully sometime in the future, we'll be able to meet again in person. So without further ado, I will share my screen and get going with the presentation. And in particular, I'd like to convey you to sort of an overview of the pandemic situation, a little bit like Martin did at first for Germany, except that in my case, I'm not a legal scholar, which is my usual disclaimer. However, a lot of what happened has been shaped by law and by institutional and organizational change. So, the outline of my presentation goes as follows. I'll talk about agri-food system resilience capability, and I would like to introduce the concept. It's been mentioned many times through the presentations I was able to attend, and it's rampant throughout most of what's happening right now in the different countries as to trying to understand how we can build a resilience and what does that entail. Then I will go over the exogenous shocks to the agri-food chain that we've witnessed in production, processing, as well as distribution, and the retail and food stores. Look at food demand, the autonomy for food within a jurisdiction, in particular Quebec, and the solidarity movement that has emerged as a result of the pandemic. Go over a little bit the agri-food policy, and it's been alluded to sort of in the background, the Sustainable Development Goals and the food chain, so which I will address more directly in the presentation. As Mitroff has underscored, right now, the pandemic is actually creating a wicked mess. And one thing that I always put forward is to have a conceptual framework, a way to think about problems and to try to look at food resilience so that can be put into place by stakeholders. The idea is that getting the greatest food security for the greatest number. Now, a systems perspective is key to take into account the complexity of different types of food systems, as well as the social, economic, biophysical processes involved at different levels. So this framework ought to, on the one hand, abate weaknesses, and on the other hand, reinforce the capability of the food system while taking into account uncertainty. Now, what I'm going to present is not from me, it's coming from a scholar in food security, Tyndall, and this is how it goes. The food resilience capability is not exactly whether the system is resilient or not, but rather the extent to which it can be resilient. So what we have, for example, is the idea of robustness and the capacity to withstand, which can be high or can be low, depending upon the robustness of the system to absorb an initial shock. Now, the capacity to absorb that shock, depending upon where you start from, will be different whether you are on a less resilient curve or whether you are on a more resilient curve. And therefore, this will also spell out the rapidity and the reactivity of the system, whether you are down below here or whether you are on that curve over there. And therefore, the notion of resourcefulness, which determines how much of the food security is recovered, together with the different capabilities, an action capability cycle, are important for understanding that process. Now, one other element of that theory is that there's an action cycle, and there is one that's sitting out there, which is sort of like status quo or preventative one. However, there are stressors out there that are likely to attack the absorption capacity, the capacity to react, and the capacity to restore, so that at the end of the day, something can be learned from it in order to help build further robustness in terms of resilience. Now, those 4 dimensions that are important to keep in mind are the robustness, the redundancy, the way that you can actually substitute whatever is happening now for something different, the way to adapt and to react, which has been underscored by my colleagues speaking previously, as well as the resourcefulness put together in order to adapt to the new situation. So I'm just going to go over what happened in the food sector and basically in the supply chain from the producer, processor, distributor, and retailer/food service to the end consumer. All of that in the backdrop is the March 13, 2020 decree in Quebec declaring health emergency. So I thought that you may be sensitive to this. This is an excerpt from the publication of the decree in the Gazette based on the Law 118 on public health. And based on the WHO declaration the day before, and given that there's a law that protects public safety, the government can declare a state of emergency on its territory or parts of it in order to protect the population from a pandemic that is a real threat. So this is essentially what happened in many countries around the world. And this is no different, except in this case, the jurisdiction that oversaw that is provincial. Now, what happened is similar and parallel to what has been described by Martin initially about Germany. At the production level, we had initial surpluses, for example, the impossibility to deliver milk because of school closing and food service closing. So a lot of hectoliters of milk were wasted, and part of them were also deviated toward making butter and additional cheese that was ultimately delivered to food banks. However, there's surpluses happening there. There was uncertainty regarding the presence of foreign workers, especially in March. It's the beginning of field work and what would happen over the harvest period, given that the Canadian government imposed a moratorium on all travel and that anyone coming into the country had to quarantine for 14 days. Now, the law was sort of eased some to allow foreign workers, but that took some time to work things out. And in many cases, a lot of the workers didn't show up. Now, the reduced capacity to deliver animals to processors because of processing plant closing costs the producers, especially hog producers, to euthanize animals on farm or to actually delay the delivery to plants which were operating at less than capacity, which meant, additional costs for keeping the animals and feeding them and so on for some period of time. Also, the reduced capacity to harvest vegetables from the field, harvest going to waste. And as a result of that, many developments occurred in terms of short chain, and producers invited consumers onto their farms, respecting physical distancing, to harvest for free some of these vegetables and to take them home. Parallel to that, we alluded to in previous presentations about the online or transactional websites and delivery, the direct delivery to consumers that occurred at the farm level. So, and given that this started all in March, and it's still now we're sort of in a second wave, a few days ago, it was shown that, Quebec hogs would be sent to the US for processing, which is not something that has occurred in the past. So because of plants having trouble with processing and becoming hotspots for COVID-19. Now, parallel to that, the government put into place, here we see our Quebec Prime Minister, a campaign for local buying of food products, and an organization that is located south of Montreal established a interactive map so that consumers could find their favorite suppliers or processors to buy food directly from them. Now, there was also another policy introduced to try to get Quebec-based labor to work on farms. Now, two farmers here, one saying, "What happened? The guy is exhausted." He said, "No, I just described to him what the job was all about." So it's tough to recruit people to work on farms, and therefore the sector is heavily dependent on foreign workers. Now, at the processing level, we have a pandemic that has still have impacts on food processing at the moment. Sharp increase in processed food at retail as the food service has nearly shut down. First wave, summer was nice. However, now second wave in what we call red zones, which is most of the urban areas. So downtown cores are basically suffering a lot in Montreal and Quebec City, for example. Sharp increase in food service, restaurant. So this is actually declining quite substantially. Lower activity level at processing because of plants becoming hotspots, labor shortages, and reduce processing capacity as animals remain on farm. Now, plants are impacted differently based on plant size, of course, and also the development of transactional websites and direct delivery to consumers from processing plants. And we have a case with a cheese manufacturing company that actually started to deliver directly to a consumer and bypassing retail altogether. Now, at the distribution and retail and slash food service, this is pretty similar to what has been seen in many other countries. There's an overnight shift for demand from food service to food retail. More labor was hired at supermarket, improvement in working conditions, wages and salaries were increased. The food chains also adapted just-in-time procurement strategy and tried to bypass large distribution centers to counter shortages in the same items that very similar items that Martin described, raw flour, soups, pastas, all those were in short supplies in the store. And also change in opening hours to help with elderly and more vulnerable customers so that they could access the store at different hours of the day where there was less people in the stores. Also step up food delivery services. Online buying was established on a measured scale, however, with considerable delay at first, up to 10 days in order to get your grocery delivered at home, the time it took to establish the process. Install plexiglass to protect cashiers, implement sanitary measures, hand washing stations all over the place. Now, food surpluses were distributed to food banks and to vulnerable population, and the food stores tried to absorb the surplus from the food service segment and to reroute stocks to ready-to-eat food counters at the supermarket. In order for that to occur, there had to be adjustments to labeling measures to facilitate food distribution, at least at two levels. One is to send food directly from food service to bulk to retail, which requires a different labeling of food, as well as ease on the bilingual food labeling, as all food labels need to be in French and also in English across Canada. Now, in terms of food demand, autonomy, and solidarity, I sort of put these three items together. We are looking at dimensions of food demand which are evolving as we speak right now, and could still evolve for months or years to come, depending on how long the pandemic goes for. So there's something about to be said about household income and budget, price effects, probably prices going up, household socioeconomic variables such as status, employment or not status, the precarity of employment, vulnerable groups, also residents in the Great Northern Canada that have already had difficulty to access cheaper food, where there's no rail and no roads taking food to them. So there's overall consumer behavior, food availability according to size, variety, different things that are no longer necessarily available in the usual formats. There's farm income and stability that had to be worried about. International trade. Canada is a major exporter of raw food, as well as food transportation and the availability and cost to remote and northern regions. Now, parallel to that, the Quebec government has introduced a policy to try to look at the autonomy of the food region in Quebec. This was introduced last week, as early on in the pandemic, there was a bit of a panic about whether there was going to be food shortage. And as you know, in many countries, every time you mention food shortage, everybody gets on the edge. And the food autonomy of the province became a hot topic, and a policy was introduced. So in the discussion whether some of these things will remain after COVID, we can be optimistic that some of them may remain and may serve a purpose beyond the pandemic. The other thing that we witness is all the people who lost employment all of a sudden and had to rely on help from United Way in Montreal. And there was this website that was set up that helped understand the food chain and all the impacts about the services that were basically impacted by the pandemic, the impact on all the agencies. So, for example, family, food securities agencies, women's centers and shelters, and so on, and therefore see the drastic new areas where food is no longer available to provide to the neediest within society. Now, there's already 200,000 people before the pandemic, and therefore the request for food is essentially exploding at that time. So as a response, the Canadian government set up measures, and you can see that as late as October 9th, 2020, the government of Canada put another $100 million to support food security. And this was after the initial announcement of $100 million back in April. So those are for the purchase of basic necessities, buy equipment, material, transportation, access to new distribution center, and so on and so forth. So that gives you a bit of a flavor for the impact and some of the responses. Now, in terms of agri-food policy, what we obviously will witness is possibly greater risks for producers in terms of border closing and access to labor, most likely transportation and labor losses as well, consumer income. All of those are risks, new risk sources for producers. What we've seen also is direct support to financial support to producers and processors so that they can manage with the additional cost of social distancing, putting the measures in place. And to this day, processors, food processors and meat packing plants in particular remain hotspots for COVID-19 eclosions. Now, labeling laws and regulations to help with processed food and retail sales. And what we discovered are weak points having to do with the logistics and transportation, as well as those who form essentially unprecedented shocks to the system. Now, a lot can be learned from how food procurement and distribution responded to the health risks and on policies put into place to make it more resilient while maintaining consumer confidence and trust in the food that they access. Now, if you go to the Government of Canada webpage, this is probably similar in many countries. However, the OECD cited Canada as one country where financial support were the greatest to both industries and individual citizens. So you can find financial support to businesses specific for COVID-19 programs, set up to the plate, help feed the Canadians, information about industry to access programs, and the workplace guidance also. So then you can see new news and programs being put together every day and in all parts of the country in order to help with the different aspects of the management of the pandemic. Now, all this works only if we take into account the fact that managing the health crisis itself is a big puzzle, is a complex system, and even though we think it's going to go well, in the end, we see that this is a complex maze, and therefore all of these measures work as much as you can unease the lockdown and understand how to essentially maintain accessibility to care in the health system. So one question we had is the food system resilient given the uncertain timeline of the COVID-19 pandemic? And at the beginning, I tried to give you a little bit of notions about the various dimensions and action sectors of the resilience cycle, about the robustness of the system and its ability to absorb the shock. the ability to substitute inputs and substitute outputs as well, how flexible and how reactive can it be, and whether it is resourcefulness and it can adapt to future situations. Now, what we see in terms of food security level over time is that every time you have a disturbance, it gives the opportunity to the system to absorb and also to decision makers and most actors in society to learn about the way that they can avoid and reduce the loss function over time and try to be responsive across. Now, the example that we talked about the food chain is what we've seen with the emergence of direct distribution from producers or processors is the ability to use IT, in particular for those who set up transactional websites, to disintermediate the supply chain from producers to consumers. And those are likely to be new patterns that will emerge in the future, and they may change the structure of how food is produced, processed, distributed in the future after the pandemic. As some of these investments in another project, I'm working with producers and wine producers and cider producers, and many of them have established websites, transactional websites, and set up delivery floats in order to be able to deliver the products to consumers. Now, to go with the other aspects of that is the reintermediation. Is my previous colleague mentioned the role of information in the system, and this reintermediation between the different segments of the chains are likely to be supported by technology and play a greater role in providing information to actors within the food chain. One other topic I want to briefly mention is the Sustainable Development Goals of the United Nations, and the fact that food systems are connected to every Sustainable Development Goals. And there's a list, an infinite list of issues that we could look at, and whether those are going to be staying or going away after the pandemic. For example, food consumption and sustainability of just-in-time supply, or trade-off between local versus maintaining global food procurement, or a mix of those. Also, the food stock management and food waste. For example, the overconsumption and warehousing capacity versus the energy required to keep that, as well as greenhouse gas emissions. And then how will individual behaviors influence behaviors in larger entities, in organizations, in various sectors, for example, agriculture itself, but sectors that also have a huge agri-food component, such as tourism, as well as the input for labor. Now, early on, I think Ferdinando talked about the resilience capability, as well as building it in the operationalization, looking for systems approach. This is sort of my my thing. So we think here about the Tyndall model again. So we have a food system here. You have those value chains which provide, economic value, social welfare, health, as well as environmental welfare, and many other sectors such as tourism, fiber, energy, etc. And you have the individual interest and aspirations here down, and food security overlays all of that. And to tie back to Ferdinando's initial comment about governance, those outcomes coming from the food system, the value chains organization, the interconnection with other sectors, as well as individual aspirations, all connect to and are all drivers of global change interventions and governance, which in turn will also impact the future of the food system. So I'd like to thank you very much for your attention. And if you think you'd like to forward some questions to the moderators at some point, I'll be very happy to try to respond to them. So thank you very much.
Dear Martin, really thank you to you for this very rich presentation. There are many points on which I would like to spend some time, but I was really impressed by some points. The slide when you showed the label in Quebec, Autonomie Alimentaire en Quebec, and so we were used to speak about food security, then about food sovereignty, now speaking about food autonomy. This is a general request that we are seeing, and your conclusions at the end on the discussion on what will be the new institutional model that we are going to see and to deal with. This is still a really open question, and I really appreciated even your consideration on disintermediation or re-intermediation within the supply chain. This is another question which puts, of course, even legal, very relevant legal questions. And I have seen in your very rich presentation another 2 points which only apparently seem to conflict. From one side, development of short chains. On the other side, development of online websites or online sales. Both are expression of a sort of direct relation between final consumer and producer. And it was really interesting even when you speak about food chains which are bypassing, in some cases, large distribution centers. In my sensation, but of course this is just an opening of discussion today and an occasion to work more deeply on this topic. We are just looking to a totally new set of contractual relations and even of legal responsibilities and legal rules to guarantee. And the question is also, which will be the role of the communities or the community to give an answer to this? This is another point. Of course, I have no answer now, but really your suggestions are a rich point. And this introduces me to the last speaker of the day, and I'm very grateful that comes just at this point, because Matteo Ferrari of the University of Trento will speak us about managing the COVID emergency in the global food market, the role of private regulation. So the question is just this: are we rediscovering a role of private regulation? And what is the meaning that we are going to give to this expression? What is private? Is our traditional idea of a contract between 2 individuals is a much larger, is a source of private law applying to a generality with all the problems of which are the respective positions of empowerment of people working on this. So I'm very pleased to give the word to Matteo for the conclusive speech of today. Thank you very much, Martin, again.
Thank you, Professor Albisini. So I wish to thank Professor Albisini for organizing the conference and for giving me the opportunity to speak. I prepared a few slides as well as Martin, so I will share them. And then I start with my talk. Okay, so even if it is too early to fully understand all the repercussions that the COVID pandemic will have on law in general and on food law in particular, it is anyway worth noting that the sanitary emergency has put a strain on supply chains, raising issues about the resilience norms having coping with global crisis. An increasing number of scholars have questioned the capability of risk regulation, contract law, labor law, health law, and the like to provide effective solutions to manage the COVID emergency. The somewhat implicit fear lying behind many of these voices is that the crisis might exacerbate some, if not many, of the inequalities already affecting the food market. Against this background, Article 78, paragraph 2 bis of Italian Decreto Legge 18/2020 provides that it is an unfair trading practice requiring voluntary certification related to the COVID-19 as a precondition to sell agri-food products and or to continue sale agreements signed before the COVID emergency. So taking inspiration from this provision, the focus of my presentation will be on the issue evoked by the provision, namely the role that private standards and certification schemes have played and still play in coping with the COVID pandemic. A few words must be nonetheless spent with regard to Article 78, since it represents the starting point for my analysis. In particular, the norm hints at typology of problems that are placed at the intersection between the asymmetry that often characterizes the size of the subjects operating in the agri chain, so input suppliers, farmers, processors, retailers, and the use of such asymmetry to distort a fair and balanced apportionment of risks and benefits. So understanding Article 78 against this background of the market power imbalances plaguing the sector helps making sense of a connection that the norm establishes between certification schemes on one hand and unfair trading practices on the other hand. Indeed, imposing private standards and certification is one of the ways to shift the risks associated with a given activity from a stronger subject to a weaker one. So the scenario taken into consideration of Article 78 is one centered on business-to-business relation, and in line with this scenario, my presentation will focus only on how private regulation contributes to manage the relation between business parties amid the COVID pandemic. Since the type of problem under consideration relates to the apportionment of risks, in the case of a COVID emergency, the first type of risk to be considered are those associated to the marketing of products potentially contaminated with the virus. The general message that science is sending to consumers is that eating food is safe, but real risks and perceived ones do not necessarily correspond. Even if science unanimously states that food safety is not an issue in the COVID case, consumers might fear that food can contribute to the spread of the virus. The need to react to these perceived risks could help understanding why retailing chains might have asked their suppliers to change their daily operation. A second type of risk concerns the threat to business continuity. The expression refers to the capability of a professional operator to promptly and efficiently react to internal or external menaces and disruptions in order to maintain its operability. It is a form of business resilience, since its goal is to avoid stopping the supply of products and services during and after events that adversely affect daily operation. Business continuity is one of the strongholds of private standards, and it has a prominent role in many of the documents that private standard setters have published to deal with the COVID emergency. So the ISO offers a definition of business continuity as the capability of the organization to continue delivery of products or services and acceptable predefined capacities following a disruption. So the definition implies both a quantitative and a qualitative dimension. In the case of events that threaten business operation, it is not sufficient to provide any product, but this must be in a quantity and of a quality such to meet buyers' expectations. The risks considered under the business continuity notion go beyond food safety and refer more in general to logistic aspects. Food safety can be one aspect of business continuity, but the range of the latter is wider and involves all the different facets of a supply chain. The importance of business continuity is magnified if we consider that more and more the food supply chain is a global one. In a transnational environment, logistics are more complex. Guaranteeing the capability to supply products depends on a series of factors, and some of them are out of the control of single business operators. Business resilience, and in particular business continuity, must take into account also the geographic dimension of the relation that the modern food supply chain entails. Retailing chains have a leading role within the agri-food chain and have an incentive to shift some of the risk they bear on the other players of the chain, namely processors and farmers. The modalities to shift the risk associated to COVID from the retailing level to the production level are several. The contract is one of the most intuitive. A second one is represented by private regulation. Private regulation can be conceived as a mode of food governance alternative to governmental regulation, in which private subjects develop and employ an array of instruments aimed at governing the activities of some subjects. The definition of private regulation is broad enough to encompass the contract too. Nonetheless, contract has been traditionally studied apart because of a variety of reasons. While contract is historically one of the pillars of private law, private regulation is a much more recent phenomenon that has gained visibility, especially thanks to the rise of transnational value chains. In addition, while the scope of contracts is confined to 2 or more limited number of parties, in the case of private regulation, standards and certification are more catholic in their range of application. Further, while contracts are directly binding among the parties, standards and certification schemes are not binding per se, since they are private voluntary tools. To make them binding, another legal tool is needed in the form of a contract or a membership in an association. Private regulation is based on 2 main tools, private standards and certification. Private standards are meant as norms created by private subjects regulating technical features, processes, other characteristics that a product and or a process must possess. A characteristic common to all private standards is the fact that they are set by a private subject, being a physical person, an association, or a corporation. These subjects setting the standards are the so-called chain leaders. Because of the market power they enjoy, chain leaders are able to determine the condition the other chain players must comply with. In other words, they set the rules of the game. In the case of a food chain, supermarkets are usually the chain leaders. Certification schemes can be conceived as the enforcing tool of voluntary standards. In order to understand how certification schemes work, 2 different point of views can be adopted. The first highlights the etymological origin of the word certification, which derives from the Latin certum facere, and in its term, certum comes from cernere, a verb that means to select. Therefore, certification schemes operate a selection. Any selection implies the use of a yardstick, a benchmark. In the case of certification, private standards are such yardstick. The second viewpoint employs the notion of information asymmetries. The role of certification with regard to information asymmetries is to contribute to fill them. Especially in the case of credence attributes, the certifier assesses the presence of given qualities, for example, organic, on behalf of a class of subjects who are unable to detect them autonomously. So my focus will be on a few standards and related certification schemes widely employed by the retailing industry. These standards encompass both quality in the sense of management and safety aspects. The reason of the choice is that, as noted, 2 main types of risk arising amid the COVID emergency are related to food safety and business continuity. In particular, I will consider the following standards. So the British Retail Consortium, so-called BRC standard, the International Feature Standard, IFS, the ISO standards, and the Food Safety System Certification Scheme 22,000. 2 additional elements are worth to be stressed. The first is that even if contract and private regulation must analytically be kept distinct, this does not mean that the 2 are not operationally intertwined. Compliance with private standards is almost invariably the subject of contractual clauses by which one party commits himself to supply only products that fulfill 1 or more standards. The second element is that the symbiotic nature of contract and private regulation can be better understood if we consider that the 2 share the same horizon. This is represented by the imbalances in power that first characterize especially, but not only, the relation between retail engineering and suppliers, and second, operate at the global level. 2 paramount threats seem to emerge amid the COVID emergency. The first consists in the risk to market products that can be vehicled for the virus. The second in the risk that, because of the restriction established to limit the spread of the pandemic, the smooth functioning of the supply chain will be in jeopardy. In order to understand how private standards and certification have been employed to manage such risks, 3 topics will be considered: the AJCCP plan, the supplier's approval procedure, the business continuity principle. The AJCCP plan is the natural place where to assess if COVID-related food safety risks have been considered and to identify the possible measures to manage them. In preparing and reviewing their AJCCP plans, firms do not act in a vacuum. Usually, they receive some direction from consultants, professional associations, certifiers, and standard setters. Therefore, the analysis should consider suggestions and/or guidelines published by these subjects and related to the management of the COVID risks. All the standards I considered at least, seem to adopt a similar position. COVID does not pose a direct and serious threat to the safety of foodstuffs, and therefore does not need a special consideration under the AJCCP plan. This conclusion is supported by scientific evidence. Health agencies, as I noted, agree that the COVID virus cannot be transmitted via food consumption. Anyway, the BRC case is interesting. It does not establish that the firm should review the plan in order to directly consider the risk of getting the virus via the foodstuffs. Rather, it invites to update the HACCP procedures when changes to the production process are introduced because of the virus. Thus, changes in the type of raw materials employed, frozen material versus chilled material, in the production line speed and the frequency of the testing, for example, because of the reduced number of the staff, or in the cleaning procedures, because, for example, the new detergent employed, can affect food safety and therefore need to be considered under the HACCP system. The other point is about the supplier's approval. The supplier's approval refers to the requirement posed almost invariably by all private standards to set up an approval and monitoring system for suppliers in order to ensure that any potential risk from raw materials, including packaging, to the safety, authenticity, legality, and quality of the final product are understood and managed. Chain leaders are in a contractual relation only with their direct suppliers. Any sub-supplier the direct supplier employs is by definition out of the range of a chain leader's control. Nonetheless, sub-suppliers play a crucial role in guaranteeing the safety, quality, authenticity of the final product. Therefore, the chain leader has a keen interest in exercising some form of control, even on sub-suppliers. Supplier's approval requires the direct supplier to employ only sub-suppliers who have been pre-approved who can assure compliance with minimum requirements in terms of safety, quality, authenticity. The COVID emergency can disrupt well-established supply lines, for example, by making unavailable raw materials satisfying minimum requirements, or by reducing the volume of products sub-suppliers are able to supply, or again, by making impossible the shipment of their products. Of course, the fact that sub-suppliers are unable to supply their products will reverberate on the direct supplier, who in its turn will be prevented to supply the chain leader. Therefore, in order to maintain their supply steady on running, chain leaders and direct suppliers might have to resort to new suppliers and sub-suppliers. In an emergency context, following the standard procedures required to approve these new suppliers and materials might prove too slow and costly, if not impossible. All the standards under consideration, therefore, include the possibility to follow emergency procedures for the supplier's approval. The clearest example is offered by the BRC standard, that provides for alternatives to in-situ audit for suppliers, such as online searches for site issues, request of product samples, review of audit reports done in the past, and also remote site audits. The supplier's approval procedures are part of a broader set of requirements that, if observed as a whole, represent one of the main pillars of private regulation. The reference is to the principle of business continuity that, as noted, refers to the capability to react to an emergency in order to maintain the productivity at acceptable levels. Business continuity performs a crucial role in the COVID context because it is the tool that standard setters specifically conceive to manage the situation of disruption that can follow an emergency event. The IFS standard states that one of the most important steps right now, so meaning during the COVID emergency, is the activation and deployment of a crisis management protocol to enforce a business continuity strategy and assist product supply. In the COVID case, the relevance of a strategy for ensuring business continuity is clear. Maintaining supply chains running is vital for chain leaders. Employing suppliers equipped with alternative strategies for their production activities in a context of disruption represents a priority. In the future, it is likely that the lesson taught by COVID crisis will drive chain leaders to require more and more compliance with standards imposing the business continuity requirement. So, some conclusion. The way standards and certification have been used to deal with the consequences of COVID is representative of a broader set of issues revolving around the interplay between private regulation, globalization, and crisis management. According to me, there are at least 3 points that seem worth to be stressed. First, flexibility is commonly recognized as one of the key features of private regulation, and it is an important variable in explaining why standards and certification schemes play a role in managing the COVID emergency. The need for flexibility is due not only to the fact that in a scenario of emergency, the imperative is to cope quickly with effects triggered by a crisis, but also to the global dimension crises now have. Since markets are global, also the way to manage crisis must be global. Providing global regulatory responses is difficult, especially if we take into consideration a second common feature of markets, that of being almost instantaneous. Therefore, the regulatory responses should be both global and rapid in order to meet market expectations. Public regulation is clearly hard times in satisfying these features, while private regulation, being more flexible and devoid of a geographical characterization, is better equipped. Second, the fact that the approach followed by private regulation is market-driven emerges clearly if we consider that the paramount and the overarching goal of private standards is to guarantee business continuity. This type of approach is unilateral in a twofold sense. First, because it considers only the market and not other interests, some values as well as some stakeholders who do not partake to the market dynamics are placed outside the private regulatory horizon. Second, because it is promoted by the stronger party in a context of power imbalances. Private regulation can thus exacerbate those imbalances and give rise to unfair trading practices. The operational consequences of the unilaterality of the market-driven approach are manifold. For example, one possible consequence is to limit the possibility to invoke the force majeure doctrine. The unpredictability of the Covid crisis has moved many scholars to explore the possibility to terminate or to renegotiate a contract because of the disruption to the supply lines caused by the pandemic. By imposing to consider ex ante other supplying alternatives in cases of unforeseen emergencies and/or disruption, business continuity can arguably transform what is unpredictable in something at least partially predictable. In this way, the chain leader is shifting the risk of unpredictability on the weak party, and at once he can claim that force majeure should not apply. Third, private regulation is not acting in a vacuum. It must be placed in context. The context is represented by the presence of public norms that, at very least, set the boundaries within which private regulation can operate. In other words, these norms pose limits to the regulatory autonomy of standard setters. One example of an explicit limit is Article 78 of the Decreto Legge 18/2020. Implicit limits are much more frequent and can be found in general principles such as those of public order and good faith. But the relation between public and private normative spheres is not unilateral, as the idea that public law limits private regulatory autonomy might suggest. Indeed, what is interesting further to note is the interplay between private and public regulation, and what has been called the hybridization of food governance. The expression refers to the fact that private standard setters ask for the support of public institutions in endorsing their private rules, and vice versa, public regulators borrow private standards and sometimes use them as a substitute for public regulation. These mutual and iterative exchanges between the two spheres are beneficial insofar competencies and responsibilities of the two are maintained clearly distinct. The mistake to avoid, according to me, is that public regulation relying substantively on private standards and/or abdicating its role in setting the boundaries for private autonomy. So, thank you.
So, Pier Matteo, thank you very much for your presentation. This is the final speech of the day, and this is a very long day, and I don't want to take too much time to you, but there is one question, a final question. Who is this private regulator? Because under this word private regulator, I see at least three different possible subjects. When we speak about big private regulators, we think about big traders, big chains, supermarket, and so the power of buyers. We had cases before the antitrust authority in Italy that even large producers, very large producers, said they are in a condition to be submitted to large buyers. But that is one of the possible, images that we can have of this private regulation. The second one is standard bodies. And I must say that still today, I'm not able to understand under which sort of reasoning certification and standard bodies select their standards. This is completely unclear. Third one, there is the problem of the organization of producers, going back to the starting of this long day. So the organization of agricultural producers, or even some part of the chain of transformers, that in the last years in the European Union got some peculiar role. This is one of the topics that we usually discuss. But in any case, we have many things to deal with, and even the discussion on the ACCP method must take in consideration that the definition of hazard and risk have been deeply changed. So it is true that there is no such important, as we know now, risk on COVID pandemic when we are dealing with food, apart from the situation of people working together in some condition and so on, but not food as such. But nowadays, even in the food production, we are bound, or the producers, or anyone who is along the food agri-food chain is bound to consider the effects on the general cycle of life. And so the example that we had just about Nice recently is a clear example. But I don't want to take too much time. And of course, if anyone of the speakers of this afternoon, of this morning, wants to add something, of course, it will be a pleasure. I see Professor Costato on my screen. I don't know if he wants to add something. Otherwise, if there is nobody who wants, and we are all much more rich than this morning in ideas, in my impression, not in final solutions, but ideas and suggestions a lot. I thank you all very much for being here, for the contributions, and see you tomorrow morning at 9 o'clock. Thank you again, and thank you again to the technicians of the university that helped us so much, and to the colleagues from very far away. Have a good evening. Bye.
E domani ancora dobbiamo ritirare.